One billing these changes as a win for small and medium business.
Our next guest, though, says there are far bigger fish to fry when it comes to getting the unfair dismissal system right. Joydeep has authored 2 editions of the book Managing Termination of Employment and is the managing principal of People and Culture Strategies. Joydeep, good afternoon to you. A win for businesses, how the government has termed these changes today. What are some examples of the practical difference that these changes will actually make, though?
Yeah, I think to put this in context, Brooke, Carson, good afternoon to you both. The Fair Work Act review that was handed down a few months ago was fairly low-key. I think notwithstanding there were 51 recommendations, the general consensus, and certainly my view at the time, was that it really wasn't grappling with some of the more significant issues. Within that context, there were a number of recommendations made to the general rights and remedies available to those employees who felt that they had been unfairly dismissed. Some of those recommendations were very squarely targeted at weeding out those claims that were deemed to be vexatious or otherwise unmeritorious. Now, in today's announcement, I understand that the legislation that's going to be tabled before Parliament will pick up on many of those recommendations, introducing some greater powers for the tribunal to address these matters and stamp out those claims and make costs orders and other things. But what it also very interestingly does is it picks up on a recommendation that was made by the panel that conducted this review, that the time period within which those claims have to be brought is actually pushed out now from 14 days to 21 days. Now, there are a lot of businesses, and certainly a lot of our clients, whose experience has been that they have been able to resist a number of claims that were brought by people outside of that 14-day time period. If you accept that logic and accept that that's a reality, there's going to be a number of additional claims that will be brought by those individuals who, rightly or wrongly, didn't know that they had 14 days to bring a claim and now have an extra week.
Well, Joydeep, time frames aside, you've got some who are maintaining that there are serious deficiencies remaining in the legislation. What is coming back time and again as, you know, top of the list of bugbears?
I think if we look at unfair dismissal as a jurisdiction, it's been in place in Australia for well over 20 years. It's a part of the employment landscape here, it's part of the workplace relations infrastructure. But you only have to look at some of the quite controversial decisions over the last 12 months, not the least of which is a decision of the full bench of the tribunal, which confirmed the reinstatement of a dismissed Linfox employee who was sacked by Linfox for posting derogatory comments and other offensive comments on Facebook. And we've talked time and time again about the challenges of social media in the workplace context. But one of the real challenges there was that the employee was found to have done the wrong thing. It was quite offensive content, racially offensive, sexually offensive content. The employer came unstuck largely because it didn't have a policy on social media, and it was somehow held that this was some kind of exercise of free speech, and it was perhaps an unfair extension of the employer's prerogative to dab into private activity. Now, there are employers out there that will be looking at that decision and say, hang on a second, on the one hand we've got discrimination, bullying and harassment laws that require us to really address inappropriate workplace behaviour, whether that's in the workplace, outside the workplace, so long as it affects co-workers, it's in the game. And yet when we do take that decisive action, as we think we're required to do, we come unstuck and the employee gets put back. These are the real challenges that employers are facing out there. As you say, time frames aside, until such time as there's an endeavour to grapple with these things, I think the system remains highly problematic.
So is that area likely to be tackled, would you expect, you know, based on what you've seen from the review of the Fair Work Act, or even the fact that the government's saying there may be some further changes into next year?
Well, I think the limit of what the government's saying around any future changes are confined to any of the recommendations that were made by the panel. None of the panel's changes went to any of the substantive issues of unfair dismissal, or indeed that new type of claim which was introduced by the Fair Work Act, those general protections claims, which in practice are operating as de facto unfair dismissal claims for those who are earning above the unfair dismissal threshold, remuneration threshold of about $123,000. So there's plenty of scope for dismissed employees to challenge. I think the employers around the country would be saying what we'd really like is some clarity around when we can and can't dismiss employees. And the government may well say, well, that's why you've got a separate arbiter, Fair Work Australia, and that's up to them to decide at their whim what is fair, what is unfair.
If any lesson can be taken from that Lim Fox case, briefly finally, is that in the absence of implementing policies that are clearly delineated, you cannot be one to cry foul if you get a similar reinstatement order.
Well, that's right. I think the employers need to look very closely at the issue of policies, but I think that would, for many employers, be seen as a technical argument. Ultimately, employers are trying to do the right thing by a number of other sources of legislation, anti-discrimination and harassment legislation being another. Tough to be an employer in Australia in 2012.
Nothing worthwhile is ever easy, right, Joydeep, as you would well know. Thank you so much.
Good to speak to you.
Appreciate it.
Thanks.
Okay.
That's a Joydeep Hall from People and Culture Strategies. We move on to some economic